Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in case number 1CA CV20-0508, Wiles et al. V. Jones et al. A couple of housekeeping items before we get started. In more normal times, we'd have you stand at the center podium. Today, you can stand at the podium there at council table throughout the proceedings. Also, as you can see, our panel is physically distanced. We have removed our masks to make it easier to communicate with you. You are welcome to remove your mask during argument. Of course, if you'd like to keep it on, feel free to do so as well. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you choose. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Good morning, Your Honors. Stephen Kubashevsky. I represent the Jones defendants, and we are the appellees or the appellants in this matter. My client, Gordon Keith Jones, is in the back in the T-shirt in the far left, and he is present in the courtroom to observe the oral argument. Do you want to have introductions first? Or do you want me to proceed?
Go ahead.
Thank you, Your Honors. This case it's a very complicated, convoluted, procedurally postured case. So what we're doing here today should be a relatively simple matter, but it's frankly, it's not. So when you talk and you take a look as to where we are, the very first thing that I want to identify is there's a disagreement on the standard of review as to what this court is supposed to be reviewing this case for the decision that was made at the lower court. Our position is clearly that this is a de novo review because it's purely legal. And to substantiate why this is purely a legal argument.
And before we get, though, to the standard of review, maybe we should talk about the scope of review. Because this case was remanded for an attorney's fees issue, and now we're here supposedly evaluating the propriety of a trustee's appointment.
Correct.
It strikes me that this entire case has several examples of mission creep, and that we are well beyond the scope of review that we should be engaged in, or at least that's what you're asking us to do.
So Your Honor, to a certain extent, I certainly understand where you're coming from. But when I get 54B or 54C language at the end of a minute entry saying there's nothing further for me to do, I'm left with very, very little alternative.
And I understand that. I'm not suggesting that we lack jurisdiction over this, but I am suggesting that unless we get a handle on what the issues properly before us truly are, these proceedings are going to do more harm than good to this trust.
So, and again, I agree with that from a perspective of where do we go from here, but we're going to need the court's guidance in how we're going to attack this thing going forward, because there's two matters that are pending. There's a 2014 matter which has not been resolved because it's remanded back to the court for determination, as you've mentioned, on the attorney's fees question, and there's a 2015 matter which I consider to be a sister case making very similar allegations, which was part of the subject of the original appeal that the Court of Appeals has already decided.
And there's another piece of complexity which is not the fault of anybody here in the room, but I think we need to address head on. And that is this notion that in the prior memo decision from this court, the settlement agreement was invalidated in its entirety. And I want to lay the issue out because I hope both sides will address this, but it strikes me that there is a difference, a material economic difference, if nothing else, between what the court said and what the court did. The memo decision from this court said that the settlement agreement was invalidated in its entirety. Yet the original case remains dismissed to your client's benefit. And it was not reinstated. Your clients are not defendants in that case anymore. And so I really wonder how we can say that the entire agreement is invalidated.
So that's what the Court of Appeals said at the last decision, is this whole thing, the whole agreement's invalidated. So this gets brought back to the lower court for determination of the affirmation of the successor co-trustees, which was part and parcel of the original agreement. Term number one required my client to resign and for his dad to resign effective on a date certain after he appointed the successor co-trustees, which are now, I think, theoretically the appellants or the appellees in this case.
Well, that's part of the agreement. right?
Sure,
The
that
other
was-
part is
sure.
the case will be dismissed and your clients are no longer defendants, no longer subject to additional personal liability, all of that. So I am perplexed as to how we say it's a nullity. It's not a nullity. In practical reality, it's very much binding.
Okay, so in that regard, I would ask the court's assistance then in binding the agreement, because in the court's decision that was made prior, in the previous appellate action that came to this court's for review, actually the only thing that I had asked for is to have the trust be found a party to that agreement. That was what I had asked. That's the only thing I'd asked for the Court of Appeals
now I
to do.
think we're well into mission creep, and now
But
we
it's-
cannot go
it's-
into that earlier decision and reanalyze it and unravel it.
So-
What we
so-
can do is precisely state what the scope of that decision was.
And I would ask for your assistance again, and that's what I'm asking this court to do, is assist us in what is the scope of that decision. Because if the agreement is invalidated, if it's basically it didn't happen, but there's certain things that did happen as a consequence of the agreement, do we set those aside? Do we affirm those? What do we do going forward? So the first piece of information that was brought to the lower court was whether or not we're going to affirm the resignation and the appointment. That's term number one, and the court did. My question is based on what authority? What was argued to the lower court by the plaintiffs and the appellees in this matter is that there's a difference between the agreement as unenforceable and a judgment which is yet to be set aside by court order or by appeal or by Rule 50 or 60B motion or 60C motion. That's never happened to this judgment, and it's a signed agreement signed by a superior court judge, and so it is technically a judgment, and I would agree.
Your client resigned from his position as trustee.
My client resigned as part and parcel and pursuant to the settlement agreement as part of the benefits of his bargains,
But
which he's not getting.
Don't interrupt me.
I'm sorry.
He's not asking to be reinstated as trustee, is he?
My client now is asking to be reinstated as trustee, absolutely.
And what basis does he have to do that? Why does your client have any more standing to ask to be reinstated than I do?
My client was the only one that was appointed pursuant to an absolute unilateral discretion of his father, who was appointed as a successor trustee by Mr. O'Connell. Mm-hmm. My client's father appointed him under no duress, under no agreement, under no contingencies, appointed my client to serve with him as the successor co-trustee. The now successor co-trustees were only appointed pursuant to the agreement, which is now a nullity.
Well,
so my client would have...
If again, I come back to, if the agreement were a nullity, we would be entering some sort of 60C relief that makes your client, rather than a trustee, makes your client into a defendant. And I don't think that's what you're asking for.
So, sort of.
You want to be a defendant?
So the answer is very simply this. My client has yet to be given an opportunity to be heard and defend the charges that were given against or levied against him. He's had no evidentiary hearing. His father had no evidentiary hearing. We had no chance to show.
The case.
If
he wanted that due process, he would have to settle.
Of course, but how can the case be rebrought against him by somebody that settled the case?
Wait, who settled the case?
The trust.
But it's
The trust.
The secondary beneficiaries were not a party to that settlement agreement.
Correct, and they aren't a party to this agreement. They're not a party to this case yet.
But the
Right?
trustee's bringing it, the current trustee, to the extent there is one, is bringing on behalf of the secondary beneficiaries.
Brought the second case ostensibly on behalf of the secondary beneficiaries, but that's not the only thing. They brought it on behalf of the primary beneficiaries who are now dismissed as parties because they've been paid out. The court, if you look at the appeals decision that was originally entered, this Court of Appeals found that there are similar claims being brought on behalf of the primary beneficiaries who have clearly settled that case.
With whom?
With my clients.
Okay, and so if that agreement is a nullity, is the result that you're looking for today the idea that your clients now become defendants in 2 lawsuits, that the settlement is a nullity, and we just do all this over again?
Procedurally, it's much, much different than that.
Well, perhaps, but the end result of what you're suggesting, if we're going to actually put the pieces where they belong, is that your clients get to defend themselves and have all the due process and the right to testify and everything in 2 cases, which they are now not party to, and then argue that somehow that transforms them back into trustees. Is that the world you want to see at the end of this day?
So at the end of the day, there's a pick or a choose. There's got to be one or the other. They either have to be reinstated and put to square one before they entered the settlement agreement, which was the posture of being the trustee, having discretion over the trust, how the distributions are made, being able to monitor the trust, invest, and do the appropriate things according to the terms of
Did
the
you
trust.
ask for that relief in the first case?
I did.
Here, in the Court of Appeals?
My recollection is I did. That's part of the options that I presented to the court. It's part of the options that I present to the court today.
Are your
If my-
clients beneficiaries under the trust?
No,
Then whence their seemingly insatiable desire to serve?
because they keep getting assessed attorney's fees and they keep getting brought back in for their service as trustee, not only in the 2014 matter, but in the 2015 matter. So if they're reinstated in the 2014 matter, the 2015 matter no longer has a plaintiff and goes away.
As long as they're reinstated, then the trust won't sue them.
Correct.
That's convenient. Okay.
So well, to a certain degree, yes. But if you look, because one of the analysis that went on, and I think this is getting what you would call a field of what the arguments are for today's purposes, but the public policy argument that was brought in the last matter is what you just alluded to. It's convenient for my clients to avoid this and to dismiss themselves. If they settled the first case with the original plaintiffs on money damages alone, they would never have been removed. That doesn't put Mr. Parker's client in any better or any worse position than they are today. They still have their rights because they weren't party to that settlement agreement. They could turn around and sue us at any time and have yet to do so, and 6 years has passed. They've never stepped up. So if they want to say, oh, it's very convenient for them to just avoid it and let the new successor trustees bring the action, the primary beneficiaries have all been paid. It's just Mr. Parker's client's money that's left. So if they're going to fund this litigation, why do they need two attorneys to do so? Why can't Mr. Parker represent the contingent beneficiaries and bring the appropriate lawsuit against my clients? Because that was preserved in the settlement agreement. That's all that was preserved. For my clients to get the benefit of the bargain, the trust was involved. This court, this appellate court, found that the trust was a party to the agreement and then just set the whole thing aside as if it didn't happen. At least as, from my client's perspective, he got zero out of his benefit of the bargain. Nothing.
So I come, well, let's analyze that, because I was about to come back to the question I started with, which is the proper scope, the proper way to read the earlier memo decision from this court. The earlier memo decision from this court declared the settlement agreement unenforceable because of a dispute involving the secondary beneficiaries, right?
That's a fair reading.
There was actually no properly joined adverse party alignment that would support an unwinding of the settlement agreement as related to the primary beneficiaries or the first lawsuit, correct? Because your clients,
Right,
that
but-
lawsuit was never reinstated, it was dismissed, your clients aren't defendants.
But who were the parties, Judge, in the first lawsuit? In this lawsuit? Who were the parties?
Well,
You've
wait,
made,
this isn't the
this
first
court made the
lawsuit.
decision.
I'm
This,
not-
this court has made the decision on the settlement agreement that was entered that the trust was a party. That's part of the order that was issued.
Yeah.
So if the trust is a party, successor trustees are bound by former trustees' actions. How can they settle the case against my clients and bring it again? They're out. The trust is out. Can't bring a lawsuit. The successor trustees are not new parties. It's the trust. The trust is the bound. The only operation that the trustees have is in the four corners of the trust document. And when that trust document was represented by trustees, successor co-trustees, in this settlement agreement, and they settled the case on behalf of the trust can no longer bring an action against my clients in their individual capacity or as trustees.
Is this trust capable of serving as a juror entity and being sued?
No.
Okay.
Has to go
So
through
then when we
trustee.
talk about trust as party, are we even having a relevant discussion? How is the trust a party?
The trust is a bound entity because it was bound by the former trustees to this settlement agreement.
Okay, but that's very different from saying it's a party.
It is it's a distinction, but I'm not sure how significant that distinction is.
So even if then the trust is a bound entity, they couldn't sue your client for breach of fiduciary duty in entering to that agreement and binding it?
Judge, that's my position. That's exactly correct. And last time that I made that position, it says, oh, that's very convenient for my client, and they remanded it because that's against public policy. So my client wants to be heard as to why it's appropriate.
So your clients are still defendants in the second lawsuit?
Correct.
Okay.
It's not
And
brought by...
Their best shot at winning that lawsuit is not to defend it on its merits, but instead to take over the trust and dismiss the case on their own behalf, which
So-
is what you're saying the strategy is, which sounds a little bit like self-dealing to me.
So, Your Honor, I would have to say that I'm culpable for the problems that are created to a certain extent. I thought this was going to be a very simple, very straightforward case, and rather than doing a disclosure statement, conducting depositions, conducting discovery, going through a whole bunch of different things in the 2015 matter, if I did a simple motion to enforce the settlement agreement and it was sustained, this would be over.
Well, okay. But
Except-
let's get back to my question, shall we?
Sure.
Why isn't it completely impermissible self-dealing for your clients to try mightily to become trustees when their goal at that point, their only lawful goal should be to serve the beneficiaries, and yet they're doing this on their own behalf so they can dismiss a case against them to the detriment of beneficiaries? We're supposed to be party to that?
So since that's a hypothetical, Judge, let me answer it this way. The courts found no reason in the previous decision as to any benefit that it could possibly have for dismissing this case. My client's position on this case, the 2014 and the 2015 matter, is that they are meritless and frivolous and brought for the purposes of harassment. So when my clients dismiss it, it's to the benefit of the contingent beneficiaries. We can argue that.
There's also a forum for vindicating those arguments, right?
Yeah, that's not here.
Go to the court and prove that the lawsuit's meritless and frivolous and have it dismissed.
Right. So that's when I said, let's come here and see if this can be done by a simple motion, not to the Court of Appeals. When I filed my original motion with Judge Klein, he granted my position. Mm-hmm. He reversed himself on a motion to reconsider for the sole reason that he didn't believe the trust was there. And that was changed by the Court of Appeals. They said the trust was there. And so now we go back and we say, okay, well, now what's next? Now what are we going to do? When are we going to have a hearing? When are we going to have a trial? None of those things ever happened for my client's benefit because he's the only one that's bound by anything.
And you make some good points as to the confusing nature of the posture we're in, and I will confess that this court may have contributed to that confusion, which is why I really want to give you a chance as clearly as possible to define how you think the 2019 memo decision from this court should be read.
So how I think that the memorandum decision should be read is that this is remanded back to the court for determination on attorney's fees as to whether or not my position, not only in the underlying 2014 case, but in the Court of Appeals decision where the only thing that I appealed was whether or not the trust was a party to that settlement agreement. It was reversed on other grounds. But was my position reasonable, and do I get an opportunity to present my evidence about the reasonableness of our position and why we want to get this case dismissed and dismissed as meritless and frivolous? That's what I think the court should help me with, to go back to the trial court and say, do that, and then go forward from there.
I think you're starting to set out upon a reasonable path, but that doesn't quite answer my earlier question, which is the toughest question, I think, in this case, and that is, how are we to interpret the 2019 decision from this court?
So you need to interpret consistently with what's been done by the lower Court of Appeals, and Judge Vandenberg has settled that the settlement entered and the court's order reflecting such, issued on November 20th, 2014, remains in effect. That's the order that I can't reconcile the Court of Appeals decision with that statement by Judge Vandenberg. And I'm precluded. Judge, I'm going to need to save some time for rebuttal, and so I'm going to sit down.
Thank you.
May I proceed?
Yes, go ahead, counsel.
May it please the court. Kevin Parker for Appellees, Residuary Beneficiaries, sometimes referred to as Contingent Beneficiaries, Marquette University and St. Leo University. To address Judge Swan's precise question in terms of the scope of the 2019 decision, I think the court looks at paragraphs 1, 14, 15, and 23 of that, and I think that answers the question. Paragraph 1, the court frames the issue to be determined. At issue in this case is whether a settlement agreement entered into between the co-trustees and 4 primary beneficiaries is binding upon successor trustees when the contingent beneficiaries, my clients, were not parties to the agreement. That's how the court framed the issue. Paragraph 14, the court identifies sort of the dispositive issue, the flex point. Here, the contingent beneficiaries maintain an interest in the trust property, but the contingent beneficiaries were not parties to the settlement agreement, therefore have not released the Joneses from liability for their purported misconduct as co-trustees. Therefore, the settlement agreement in the 2014 case does not preclude the successor trustees from fulfilling fiduciary duties on behalf of the contingent beneficiaries through the 2015 case. Paragraph 15 is the holding. This is the last sentence of paragraph 15. Accordingly, we hold that the settlement agreement cannot be applied to prevent the successor trustees from bringing the 2015 case on behalf of the contingent beneficiaries.
So would your position then be that everything after the sentence you just read is dictum? Because there's other language in the decision that muddies the waters.
Well, I don't know that I would, well, I think it is dictum, but I think the other argument is that it is you have to put it in context with the prior statements. Because the paragraph 15 is the holding, then it's paragraph 16 and 17, which discuss the enforceability of the agreement. And so I think what 16 says, in the absence of such terms, severability, we find the entirety of the settlement agreement unenforceable. But I think that tracks back to the holding. Unenforceable against the successor trustees, unenforceable in its entirety against the contingent beneficiaries because they were not parties to the agreement. So
even though the language is a little confusing, you would have us read paragraph 16 and forward with reference to the original statement of the issue and downplay the use of the word entirety.
Simple answer, yes, Your Honor. I think that is the way to read it. I think what the court didn't do is, well, in paragraph 17 says, whether the resignations, no precedent for suggesting acts performed automatically unwind. So there's some discussion of that, and I think that's because of the issue, it's sort of the side issue to be addressed based on the holding. So where does that leave us?
Would you concede, for example, that with regard to the first lawsuit, the basic economic terms of the settlement, in fact, remain in place?
Oh, absolutely, absolutely. They got a release from the specific cash beneficiaries. At that time, they were owed $500,000 each. The specific cash beneficiaries, $500, $500, $500, and $600. They hadn't been paid yet. They didn't want Kupchevsky's clients to be the trustees going forward. And so they settled. Here's our settlement is you resign, you appoint someone that we want going forward, and we give you a release. I don't think the residuary beneficiaries have ever contested, the specific cash beneficiaries have ever contested. They've never been heard from again. They haven't pressed the issue that we didn't release you. They did. They released them. They got $5,000 each in attorney's fees.
So engage in a hypothetical exercise with me for a moment. Let's assume that the settlement were invalid in its entirety. The whole thing were a nullity. Would the primary beneficiaries have any claim left to bring at this point? I mean, if we said the whole settlement's out, we're putting the Joneses back in as trustees, and this entire thing was just an unenforceable detour, what do the primary beneficiaries do at that point? They're sitting on the money. Do they interplead it? Help me imagine how that goes.
Well, it's either their money or it's our money as the residuary beneficiaries. We're not making a claim to it. Mm-hmm. They signed, we settled with them in terms of the delay in their payment. There's releases in the record signed by the residuary beneficiaries. This is the index of record 95, the petition for confirmation. That includes the releases. They got paid their full amount, and they got paid $20,000 extra because of the delay, because they had an interest claim. So they're out. They signed a release a valid release by the trustees confirming the agreement that the remainder beneficiaries made with the specific beneficiaries. So they're gone. We're the only beneficiaries left, and to that point, the statutes and this trust give us a say in who is the trustee. The statutes identify the beneficiaries, and it's 10704, 10706, removal, appointment. We have a say in that. The court should consider our view of it. Likewise, the trust instrument, section 4.4, I don't call it a veto power, but we have the right to remove any trustee. So it's a futile effort to appoint someone that we don't want. We're the only ones left. We want the current trustees, and we've said that over and over and over. In sort of this unwinding hypothetical, Gordon Jones can't be the trustee, he's deceased. Keith Jones, as the court has noted, he wants to, plan A was, let's use the settlement agreement to just stop the 25 lawsuit. Now that didn't work, 29 disagreement. Okay, plan B, how about you just let me go back in as trustee so I can dismiss the lawsuit? That's the whole point here. They're not beneficiaries. Their only care in this whole thing is the desire to serve is they want to then dismiss the lawsuit. They've made a suggestion that, if we're back in as trustees, Marquette and St. Leo can sue us. But they've already argued that the statute of limitations has run on that. So what they want to do is they want to be the plaintiff and the defendant. If they're not the plaintiff and the court were to appoint a corporate, they want to argue that statute of limitations has run on us. The argument we made below is that the successor trustees and the beneficiaries both have standing. And we cited this as our residuary beneficiaries joinder in the place motion for new trial is number 71 in the record. For the restatement, the successor trustee has the duty to bring a claim against the prior trustee for the benefit of the beneficiaries. That's us. That was brought in 2015. There's no statute of limitations issue. This is, to me, a contrived argument that let's put a new trustee in, let's make the remainder beneficiaries sue, then we're either the plaintiff and we dismiss, or we argue statute of limitations because my clients didn't bring the claim, because they didn't need to bring the claim, because the successor trustees did. So that's the posture here, which gets me to sort of the equitable, practical considerations. First off, separate and apart from the settlement agreement, I understand it was because of the settlement agreement, but Gordon Jones appointed Wiles and Luthold as trustees. He has the right to remove them. If he's alive, he's not. He's deceased. He can't remove them. Pursuant to section 4.1, B as in boy, C as in cat of the trust agreement, as long as as long as the current trustees are serving as trustee, that remains in effect. The corporate trustee trigger doesn't happen per 4.1B, 4.1C, unless the successor trustees appointed by Gordon Jones are no longer serving. Wiles and Luthold have been serving since almost 7 years now, so it never gets to a corporate trustee. So their only argument is, well, Keith, and I'm sorry for using the first names, but they're both Jones. Keith wants to be back in as trustee. He wants to be reinstated. But here's what the 2019 decision of this court said, paragraph 15. Nor are we willing to condone the Jones attempt to insulate themselves from the consequences of their alleged misconduct and foreclose the successor trustees from bringing claims on the contingent beneficiaries' behalf. Paragraph 22, the petition to enforce the settlement agreement did not benefit the trust or its beneficiaries in any conceivable way. The record contains no evidence to support a finding that the Joneses, plural, pursued the petition to enforce the settlement agreement in good faith. Not a specific finding of bad faith, but a finding of no evidence of good faith. And that is the person that is before you, essentially asking to be reinstated as trustee. Someone who this court has already found to have acted not in good faith. So we have the actual appointment. You have the settlement agreement, you have the order affirming the settlement agreement, and you have the actual appointment by Gordon Jones pursuant to the trust, which he can do per 4.1b, appointing Wiles and Loophole. They are still the trustees. So for all of those reasons, the Judge Vandenberg's decision should be affirmed. And in addition, the trial court, I think, has discretion and the inherent ability to appoint and replace trustees. The ARS section 14-107-04E, as in Edward. Trial court has, it's in the trustee removal and appointment section. The trial court has inherent authority to assess the situation and do what the court thinks is right. That leads me to the procedural posture of this case. The parties submitted this case to the judge without a request for an evidentiary hearing. Everybody agreed that everything the judge needed to look at to decide whether to confirm Wiles and Loophole and to either confirm or appoint going forward was in the record. To me, that's a discretionary, they didn't ask for an evidentiary hearing. It was not a summary judgment process. Everybody said, it's in the record, Judge. We just need you to decide. It's been called into question. We just need a final ruling on this because they have to be able to proceed as co-trustees and people are questioning their authority. We need essentially a rubber stamp of their authority going forward. Final point, and of course I'll answer any questions. Final point is the de facto trustee doctrine. The de facto trustee doctrine is a doctrine of common sense and equity, and under that doctrine, even if there's a glitch in an appointment, the common law recognizes we can't just reverse, in this case now, 7 years of activity.
But under your view of the case, is there any reason that we should even reach that doctrine?
No, I don't think so. I think it's a fallback. It's a backup. We argued it. We think it applies to just as an overall umbrella to address any glitch, whatever. We think it's appropriate. We think they're still appointed, but to the extent the court thinks there was a glitch,
You're more familiar with this record than we are, other than the purported invalidity of the settlement agreement, or the actual invalidity to a purportedly broad scope of the settlement agreement. Are there any other glitches I'm missing in the appointment?
No, that's it. That's it. So that's the only one to the extent there's, and that's what the doctrine, so theoretically, the hypothetical counter argument to me would be, now we know, based on the 2019 decision, that there was a glitch. I don't think that's the case. I think it was, I think the 2019 decision of this court, I think is based on the sequence of the discussion of the decision and where the holding is and what the commentary is after. I think the decision is limited to...
Help me understand a little bit what happened after the 29 decision. So we remanded for consideration of attorney's fees, right?
Yes.
Okay. And at least language in it purports to declare the entire settlement agreement invalid. Did your opponents ever seek then at that point to, I know they moved to enforce this settlement agreement previously, but did they ever seek to then like file a Rule 60 motion to set aside the judgment in the prior case and undo everything and get themselves reappointed?
They never did. They never took any such procedural action, but it was more a practical issue. Certain parties were saying, well, you're not the trustees anymore. We don't basically have to listen to you. You can't proceed with this lawsuit.
Why do they, and I think you disclaim standing, and standing is kind of a weird word to use for it, but in your response brief, you seem to disclaim standing, but I don't understand why they have any basis on which they can object to who the trustee is. They're not a beneficiary. They're not a trustee anymore. They didn't move to set aside the prior judgment that dismissed the first case that removed them as trustee, or that pursuant to which they removed themselves as trustee. Why do we care that they don't think the current trustee is the current trustee if all the beneficiaries are okay with it?
Well, I don't think this court, well, I guess to answer the precise question, why do we care? We care because people have tried to use the 2019 decision to suggest a rescission theory than a reinstatement. And so they, as we heard today, Mr. Kuczewski argued that his client, Pete Jones, is the trustee now, or should be the trustee.
Yeah, but my point is,
the question wasn't why do you care, but why do you concede?
I don't know that I could.
What, concede that standing isn't an issue?
Oh, I don't concede. I believe standing is an issue. I think the order is still in place. They're confirming their resignations. There's been no Rule 60 or appeal or anything to seek to be reinstated. So they are, at best, a hypothetical claimant. If I did something, I think I could get back in as trustee. They have not done that. I don't believe they have standing. Any questions?
No questions. Thank you.
Thank
Thank you,
you.
counsel. All right, you've got 2 minutes and 21 seconds.
Thank you,
Go ahead.
Judge. Last statement made it's really a two-edged sword, isn't it? Either we have a judgment that's enforceable, which was entered into by the successor trustees, or we don't. So if it's unenforceable, let's set it all aside and get them back to where they're going. We've done some arguments, and I've listened to some stuff that's far afield of really why we're here today.
How do you set it aside? Do you go after the primary beneficiaries and claw back the money?
If there's not enough left and there's not enough held back, absolutely, Judge.
So because of the absence of a severability clause, we're going to go after primary beneficiaries who settled a lawsuit in good faith and take their money?
Well, there's also been distributions that have been made to the contingent beneficiaries, and there's money that's in
I know, but
holdback.
I'm talking about the primaries.
So-
We would go after them and
If there's
claw back the money?
if there's insufficient funds, they shouldn't have made the distributions. There's still administrative stuff
there
that's
was
going
nothing-
on that's not my client's fault, and we need to be heard.
Okay.
So one of the things that's argued is this de facto, and again, we're hearing that how do we just set aside 6 years of activity? We don't. That's not what I'm asking this court to do. So if there's a piece of property that's sold, that needs to be affirmed because they were acting under color of authority under this trust because they were appointed pursuant to the nomination that was made. I'm not asking for that. I'm asking to go back to where my client was so he gets the benefit of his bargain. His family gets the benefit of the bargain, and the litigation ends. There's benefit to the end of litigation. That's a clear benefit to most people. And I've been in many, many settlement conferences, as I'm sure your honors have all been in, where the benefit is to end this for the purposes of stopping the bleeding.
why wouldn't he then move to set aside the prior judgment and reinitiate the prior litigation so he can go back to square one then?
Judge, it's a tactical decision because what's brought before the court is not a petition to enforce any of the other terms except the one to confirm the glitch, so to speak, on the appointment. So why do they need a rubber stamp to fix a glitch if there's not a problem with the underlying agreement? So it's not a glitch. It's not a rubber stamp that needs to happen. There needs to be authority for the court to grant it. If there's not authority to grant it, you have to look into the four corners of the trust. The four corners of the trust does not allow the successor trustees to be appointed by Gordon Jones because they're not a corporate trustee.
Oh, no.
So he could have done it, but
The corporate trustee requirement is only if Gordon Jones.
if he doesn't, but he only did it pursuant to the agreement. If the agreement doesn't exist, the appointment doesn't exist.
Council, time goes fast, and we've gone over a little bit. So, council, we thank you both for your arguments. You've given us much to think about. We will take the matter under advisement and issue a ruling in due course, and we stand adjourned.
Thank you.